Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 99 of Business SOS. We're almost getting close to episode 100, one episode away, sometime next week. Thank you for listening. Before we start, I want to ask you a favor. If you're watching this show via YouTube, I ask you to please subscribe. Every week we have some new content, especially you're a business owner, that content that will help you navigate the legal challenges that you will face in your business. Also, if you're listening to Apple Podcasts, Spotify, or wherever you enjoy your podcasts, please follow us. And also, appreciate it if you give us a 5-star review and give us comments. So, as you know, with the proliferation of ChatGPT and AI, people are now doing contracts. People are doing all types of legal work. So, I want to talk to you today about the hidden dangers of using legal templates and AI-generated contracts. So why is this important? Because I get that often in my practice. In my practice, I see people calling me or sending me proposed contracts to review, and I know whether they're generated by AI, they're templates, and I want to talk to you a little bit more about those. Those templates, in my opinion, they're a good starting point, as I said before. And I want to talk about templates first. They're a good starting point, but they're not the finished product. And why is that? And I talk to clients and say, where do you get this contract? Well, I got it through some free legal forms that I was able to download. Or they downloaded from one of the paid sites as well, something that costs like $2 to get a contract template, something that costs like $15. It depends. There are many companies that have been offering that for years. So the appeal of using those free legal templates or paid templates are low cost. I mean, it is cheap, it is fast, and they tell you do not need an attorney. And in some cases, you may not. It depends your knowledge base, whether you receive assistance. But that's basically the way I sell the product. You don't need an attorney. You can get it quickly. And you get that information that you believe is going to be helpful to your business. And a question that I ask my clients, I say, well, how important is this contract for you? How much money do you plan to make utilizing this contract? Well, my average sale is $10,000 or $5,000. And how many sales you plan to make in the next year? 25, 30, or 50 sales. So if you're going to have a contract which is going to allow you to make, $250,000, $500,000, depending what the case may be, is it worth for you to spend a few $100s, maybe $1,000 or $2,000 developing the right contract for you? And that is the question that you have to weigh. I get often calls, we need a simple contract, quote unquote, or something very easy for you to do. It might be easy for me. I'm a professional. I do this for a living, but I understand what to do. That is the difference. And I spent 20 years in practice, plus law school, etc. So I want to warn you against utilizing these contracts as the end product for your business, because they may not apply for your business. They may not have the provisions that you should have to protect your business. So I'm not going to go into that. And I get, I get comments like it's a simple deal. I get that a lot with buy-sell agreements. People buying businesses, believe it or not. They want to buy a business for $500,000, and they want a simple contract to do the deal. And I'm like, well, that's not that simple. There are a lot of intricacies that go along the way. And it's something very simple. It's very easy. We talked about it already. We're good. Or they send me a contract already prepared. I'll just give you an example. I had a call a few months ago by a client of mine who was going to buy a business. And the business included also the real estate property. So they sent me the contract, which was prepared by the broker, but the agent, and for me to review. I reviewed it and I began to ask some questions. And the deal was like almost 100% finance with some down payment, And I'm just going to use some general numbers to give you an idea what I'm talking about. So say the business was $500,000, including the real estate, putting $100,000 down. The owner was going to finance the $400,000 over, say, 10 years. So my first question was, does the property have a mortgage? Does the owner has a mortgage in the property? Is he paying a mortgage? The answer was yes. And I said, well, I don't see that here. I don't see where that's going to be paid. How is that going to be paid and when? And I said, well, the deal was that I will be paying the owner of the property the promissory note, and the owner was going to be paying the mortgage. Then when that is paid, I'll go ahead and she'll transfer the property to me. And I said, well, that does not work that way. That doesn't work that way. You cannot buy a real estate property like that because you need to have the deed transferred to you at closing, and you have a mortgage, you have a lien holder there that has to be satisfied at closing before the property is transferred to you. So you, in essence, will be leasing the property. You will not be buying the property. Well, I didn't know that. And I said, well, your agent should have known that. So long story short, they went back to the drawing board to work out a different deal. But this is just an example of how somebody could have gotten really in big trouble here, would have lost a lot of money if that deal would have gone through. But for the fact that that client reached out to me, that client would have been in trouble, would have lost a tremendous amount of money in a deal that really could not have been consummated. So that's just one example. And another example, I believe that I gave you a few weeks ago, is clients of mine. They reached out to me. They did not want to spend money in an operating agreement or a joint venture agreement to take over a restaurant and to manage the restaurant, and they did it on their own. In this case, they downloaded forms from the web, and they just created a management agreement to run the restaurant. And they brought their own supplies, they brought their own equipment. The landlord was not aware this was happening. And they began to run the restaurant. A few months later, I got a call, say, listen, we learned just recently that the person we're dealing with here, the owner of the restaurant, was not paying the lease to the landlord, and the landlord kicked us out. And worse off, they kept all our equipment inside. All the personal property we brought inside is still there, and they kicked us out. So that created all kinds of problems here, and clearly they have a claim against the other party, the other partner. They worked at the deal, and they have perhaps a replevin claim against the landlord for removing their personal property. But all that could have been avoided by having the proper management agreement drafted by an attorney with all the provisions. And the landlord should have known that somebody else was running that restaurant. It was not an employee, it was a management agreement. Let's just give you that example. From a form downloaded from the web, unfortunately, these clients lost everything. So contracts are very important, and you should not minimize the contract as something as simple as something that can be casually handled, especially when it comes down to your business. The contracts are not, they're forms to a degree, but at the same time, the provisions contained in the contract are extremely important. And it's important that you be cognizant of the fact that those provisions, if they're not drafted properly, can end up costing you your business and devastating you financially. Because I've seen it. Sometimes these contracts include conflicting language, the templates. They include contradiction. They don't include the proper jurisdiction, the venue, choice of law. They don't include dispute resolution. They do not include your terms because it is a template. The obligations of the parties will not be there. It just has a lot of boilerplate provisions that may or may not apply to your business. So it is important to be aware of that. There might be some missing or unenforceable clauses as well. You might have cases of foreign jurisdiction, believe it or not. You might have an issue that includes a AAA arbitration. Nothing wrong against a AAA or any type of arbitration clause. But when I asked the question, and in fact, I was going back to this other example, I asked for the joint venture agreement they created, and I noticed there was a AAA arbitration clause there that any disputes must be handled by the AAA pursuant to the commercial arbitration rules. So that's fine, nothing wrong with the clause. Clause was legal, was a good clause. And I said, do you know where the AAA is? No, we don't. So why was it included here? Well, it was part of the form. It looked good. Well, so the issue with that is that when you use AAA or you use any type of outside service for arbitration, you're hiring a private judge. And again, there's nothing wrong with utilizing those services, provided that you want to use them. But those services are usually very expensive. You have case management fees you got to pay. You got case initiation fees you got to pay at the beginning and at the end. In some cases, you got to pay the arbitrator's fees up front, a significant deposit, and in order for the arbitrator to get paid. And that's all done through that arbitration service that you hire. So understanding how the case is going to be resolved, or the controversy will be resolved, has to be in the contract. It's what are called dispute resolution procedures. And what happened in this case is that when you have these contracts that don't have the terms defined, you have lack of remedies in the case of breach. You have no termination clauses, and you don't have a provision for attorney's fees, then the contract really is just not a good contract. Bad contracts lead to litigation. Let me repeat that. Bad contracts lead to litigation, and litigation is very expensive. So choosing not to invest money on a contract to save some money in the front end could cost you significantly on the back end. And I know that because that's what I do for a living, and I've been doing this for 20 years. When the contract is well done, well drafted, well executed, for the most part, things can get resolved without the need to go to court. When the contract is poorly written, has vague or an ambiguous type of clauses, inevitably, 9 or 10 times ends up in court because you want the court to resolve the ambiguity. You want the court to resolve what you did not discuss in the first place because it was assumed was understood. And that happens. Okay. So I want to shift gears, that was about templates. And again, nothing wrong with them. They're a good starting point. At this point, there's no need to start everything from scratch. They're good templates to start with, but it's important those templates are worked and refined in such a way that works for your business. So let's talk about AI-generated contracts. And again, if you go to ChatGPT, you say, draft me a contract for a lease agreement, it'll draft your contract. And this is not going to be, I'm not going to go to this podcast talk about how to prompt any type of AI system. That's for somebody else to have that level of expertise, and it's a different topic altogether. But the way I look at it, the most AI models can generate contracts. But similar to the warnings or the caveats that I gave you as to the templates that you download from the web, the same applies for utilizing contracts that are generated through ChatGPT or Claude or any other system. They're all good, but it's a starting point. It is a starting point to give you something to work with. It's not going to be your final product, because those provisions also, the same issues that I brought up in the templates, most likely will happen when you use a AI type of contract. They don't understand your provisions. Certainly, AI cannot give you legal advice. It's not an attorney. It's just a computer. But it's a good starting point, okay? And it is important for you to recognize, whether or not that is going to be working for your business. It most likely will not, without having the proper legal review on your contract. You might be able to generate some type of draft of a contract with some basic provisions, but I always advise that contract, before you begin to give it to a customer, should be reviewed by an attorney and approved by an attorney to make sure that in the case there's a breach of that contract, that attorney can enforce the contract on your behalf. Let me repeat. It's important that you use any type of template or AI-generated contract that is reviewed by an attorney before you actually begin to use it with your customers, to make sure that if there's an issue that you got to enforce the contract, that attorney has the ability to enforce a solid contract on your behalf and get you paid, and to defend you if necessary. So those contracts are important because they are the backbone of your business. So if you're going to build your business, build it in solid contracts. So I mentioned to you, AI can be good for first draft. They're also good for checklists as well. You want to create a checklist? Certainly it's okay. It's not something you give it to your customers, something internal that you want to use. That is fine. But it should never be the final product. It should be something that is utilized for the purposes of getting started. Something that I recommend in the way I draft the contract for my clients, and I get often calls for, I want to draft an independent contractor agreement. I want to draft an agreement for my customers, a consulting agreement. So my recommendation is to create a contract that can be used often. And the way I like to develop my contracts is that I create the contract with the essential provisions that are enforceability and obligations. However, the terms that change could be price, could be the actual service that is going to be provided. That could be part of an addendum or an exhibit that is attached to the contract. So the entire contract does not have to be modified every single time there's a new customer. So there's some customization here, but you know that the essential elements of the contract, the essential terms that are for your protection are included in this contract. And then the terms that are varied depending on the type of deal or transaction that you're entering in, it can be changed. But you still have the enforceability because the contract becomes one, regardless whether you have an addendum or an attachment in another document that has terms and conditions. It becomes one contract. So that's the way I kind of structure the contracts that I do for my clients. And it seems to be working well. And they in maybe once a year has to be reviewed, and that's fine. There's some changes that have to be made. We can change that. But it's not going to be a complete rewrite of the contract. Might be some minor revisions, and that's fine. You can review that often as needed to make sure that the contract that you're utilizing to generate revenue for your company is a contract that is solid, valid, and enforceable, and that you can stand by that contract and you're not going to have problems with it. So lastly, I want to talk about some provisions that should be in the contracts. And this is not going to be an exhaustive list. Maybe I'll do another. I did a podcast early on about what should be included in a contract. Maybe I'll revisit that topic again at some point. But the contract should include, who are the parties of the contract. It's very important. And I know it seems simple and probably laughing, but obviously that's obvious. Believe it or not, I see contracts that the parties not clearly defined. So you're dealing with an individual, you're dealing with a corporation. Is the individual signing as an individual capacity on behalf of his LLC or his corporation? And the actual corporation's name the legal name has to be clearly outlined in the contract. If the company uses a DBA, it should be there as well. Because the first thing I do when I get a contract, I'll go to, in our case, I go to sunbiz.org and I look up the parties to make sure that the parties to the contract are listed in Sunbiz, and I know who the registered agent is, I know who the president of the company is, to make sure that they have a record in the state of Florida as a valid corporation. Is the corporation active or inactive? So I'll look at that. So the scope of services and products. If it's a service company, then what are the services you're going to be providing? And if it's a product, what services are you selling? The payment terms, deadlines, any penalties for late payments that should be included there. Any type of termination clause or cancellation terms. Is the contract, how is the contract can be terminated, or some notice, without notice? If there are any cancellation penalties for canceling the contract, that should be included there. And what I recommend with respect to this, when you develop a contract, you just write the terms in a list. Don't start writing the contract. It just becomes more difficult to do that. Just write a checklist of these terms, so that way you can, tell your attorney, listen, I need a contract. This is my checklist of terms that I need. And that makes it easier for us to prepare the contract. A dispute resolution clause, whether it's going to be through mediation first, or you're going to go to arbitration, or you're going to go to court. Again, there's no right or wrong answer in this case. It's our preferences. So how are you going to resolve the dispute? How are you going to attempt to resolve the dispute if you have an issue that you cannot resolve through direct negotiation? You need a third party to intervene. How are we going to do that? So that's something, if you have a question, you ask your attorney, listen, what do you recommend in this case? The attorney can advise you, based on your business, what approach to take. Whether there's attorney's fees involved in the case and in the contract, I recommend having a provision for prevailing party attorney's fees, simply because it allows you to recover attorney's fees if you're the prevailing party. If you don't have that in the contract, then if you're not pursuing a statutory claim, then you most likely will not be able to seek attorney's fees. There are other mechanisms that are available in the court to seek attorney's fees, but generally speaking, you need to have that in the contract in order to be able to enforce it, to collect attorney's fees. Whether there's an indemnification provision there as well, that's important to discuss. Limitations of liability, where the service that you offer, there's a limitation of liabilities. In some cases, I see, in the case of software companies, I see examples that a liability will not exceed what you pay for the software. And I'm just giving you that as an example. Every case is different. And I'm sharing this with you to emphasize the fact that downloading something from a free form from the web or having it created through an AI model is not going to give you those specific answers that are directly related to your business. So those are the questions that you ask your attorney. This is what I need. Your attorney will develop those for you. Whether there's a confidentiality clause as well in this contract, a non-circumvention clause. You cannot have a non-competition clause in most cases if it's a vendor agreement or service contract, but You don't want, a common thing that I see is that you do not want your client contacting your employees and trying to hire your employees when they're doing work for you. So it's just, give you an example of that. Who owns the intellectual property? That's another term that should be discussed when developing contracts as well. And another, and again, this is, last but not least, but the that I have here is a form selection clause. If you have a situation where you have to go to litigation, where will that be resolved? If it's going to be the circuit court, and in this case, we're in Palm Beach County, or it's going to be through another venue. Those things should be there as part of the contract and the choice of law you're going to be using. So it's not an exhaustive list, but it's a list that at least gives you something to begin to work with as you develop your contract. And again, this is simply not for you to begin to write your contract. It's simply for you to use this as a checklist or guidance. And then your attorney will help you develop a fully drafted contract. And again, the drafting process takes a few attempts. Okay, so you have a rough draft that you start with, basically with everything that you provided your attorney. Then you discuss that or send your changes via a Word document. Then you have a first draft, so to speak, to see if you're on the same page. And then you do a more refined version, a second draft, just to make sure everything is covered. And then you do a final draft that you can utilize. So it's a two or three step process, and it requires a great deal of patience to do that. But it is money and time well spent, because that contract is going to be the backbone of your business. You're going to be using that contract all the time, and that contract is going to generate a tremendous amount of money for you. So take it seriously. Don't be light on contracts, because it's going to help you. This is a good for today. I mean, I think that I made my point that, a good contract can help your business. A bad contract can devastate your business. It is important that if you're going to be utilizing, forms from the web, free forms or paid forms, use them as a starting point, not as an end point. Likewise, with any type of AI-generated contract, use it as a starting point to give you some ideas, but the end product, in my opinion, should be reviewed by an attorney, in this case, a business attorney, that if you're in business, to help you develop a final product that you can feel confident about in the case has to be enforced or defended. I thank you very much for listening today. If you want to reach me, my email is rich@richsierra.com. Again, it's rich@richsierra.com. If you want to give us a call, my number is 866-842-5202. If you want to check out our legal services that we offer, my website is floridasmallbusinesslegalcenter.com. Remember, check out my book, Business SOS, Income Legal Mistakes, Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for it at your local bookstores. Again, if you're listening to, thank you for listening today. Please follow us. We're on Apple Podcasts, Spotify, wherever you enjoy your shows. Give us a 5-star review. Certainly would appreciate that. Likewise with YouTube. You're watching this via YouTube channel. Please subscribe, and appreciate your comments and questions that you may have as well. Share with your friends. Until next week, this is Rich Sierra. Remember that my goal is to help you succeed.